This is one module in a 21-part series that the York Group has developed to provide guidance on key elements of a cloud business model, and I would encourage you to spend time going through the rest of the series. The cloud raises a number of legal issues that are not applicable for on-premise software, and in this video I will touch on some of them. Before I start, I just need to say that I'm not an attorney and I'm not providing legal advice. This video discusses some legal issues from a business perspective, and you are strongly encouraged to use your own legal counsel for advice and document preparation. So first question, do you need an end-user license agreement? With on-premise software, the end-user license agreement, or EULA, is necessary because you are transferring the right to use the product to your client. You're not handing over the product or the IP, simply the right to use it. However, with a pure multi-tenant SaaS solution, you're provisioning a service. You're not transferring the right to use the software, nor the right to run it on their hardware. The relationship will be governed by a services agreement. Keep in mind that this is true for SaaS solutions. If you're hosting your on-premise solution or running it on virtual machines, VMs, you still need to license the software. That is also true if there's client software running on the customer's hardware. You need to transfer the right to use your software on their infrastructure, even if the overall solution is a multi-tenant SaaS. There are a few considerations to be aware of if you're working with channel partners. The first issue is client ownership and the right to bill the client. What happens if the partner owns the client relationship and has been responsible for doing the billing? You need to have a provision in the agreement that gives you the right to contact the client and start billing them directly in the event of termination. Otherwise, the partner will continue to collect revenues that should be going to you. Does your partner continue to get paid for a subscription that they've sold? Had they sold an on-premise license, they would have kept the cash. They received their compensation for having generated revenues for you. But if they've sold, let's say, 4 subscriptions and get terminated, they won't have received the compensation they feel that they've earned, and this could pose a problem for you. It would not be unreasonable for a partner to sue to receive that compensation. Our suggestion is that you build a termination fee into the agreement. This could be a lump sum payment, or perhaps 50% of the normal discount for 12 months after termination. It is easier to get this agreed to when you are signing a contract rather than when things have gone badly. If your partner has been allowed to host a solution, which by the way we don't think is a good idea ever, is there a requirement for them to remove it from their server or data center? You might be asking why you would allow a partner to host it in the first place. There are some countries where data sovereignty laws require local hosting. If that is the case, we recommend that you find a third-party hoster. If your partner has your solution running on their data center and they are billing the clients as well, good luck trying to collect if you have a dispute with your partner. And if the partner has customized a solution for their customers, for example, building custom apps as a front end to your solution, what happens if you change your code base and it breaks the API? It isn't a big concern for on-premise software because the client has both applications running on their hardware and everything keeps working. But if everything is in the cloud and they can't access your solution because the connection with the front-end application is broken, there's going to be a problem. There are ways for you to manage this risk. You can provide standard SDKs for all third-party apps, you can require certification, or you can require that your partners put their source code into escrow so that you can update the APIs before you provision upgrades to your clients. If you live outside the US, you know what the Patriot Act is, and if you're a US software company that sells its solutions overseas, you probably know what it is. To many people outside the US, it is a big deal. The Patriot Act is a U.S. law that gives the U.S. government the right to access personal information on foreign nationals if that information resides in a data center owned by a U.S. company or the subsidiary of a U.S. company. This is more of an emotional issue than a practical issue. Technically, the U.S. government has to justify why they want the information, get a warrant from a U.S. court, then get a warrant from a court in the local jurisdiction, for instance Germany, before they can access the information. But the emotional aspect of this overrides the practical side. People are scared to death that the U.S. government is going to get its hands on their personal information, and this is one of the reasons the big U.S. cloud vendors are having a tough time breaking through in markets like Germany and France. The York Group helps ISVs and services companies that want to expand their cloud business. Our website offers a wide range of resources that you can access at no cost. And if there's anything we can do to help you, feel free to give me a call or send me an email.